Yes, we are.
Good morning, Your Honors. Burt Williams on behalf of the appellant, Mr. Victor Meyer. I would like to reserve 5 minutes of my time for rebuttal. Still recuperating from a little surgery. My voice may give away on me. I'll have to get a drink of water
Okay,
sooner or later.
no problem.
As the court probably is well aware, this is the second time this particular lawsuit or an alleged agreement has been before the court on appeal. We've raised several issues in the brief. The first one we addressed is based solely on the Sixth Amendment complaint that was filed after remand from the first appeal and the terms that are stated in the alleged agreement. We think Mr. Darren Meyer, the appellee in this case, action, if he ever had an action, was time barred by the statute of limitations. It appears that in the first appeal, reading the opinion in Meyer 1, as we'll call it, Mr. Myers, the appellee, admitted that the statute of limitations had run by the time he filed his initial complaint way back several years ago. And when he filed his Sixth Amendment complaint in paragraph 17, he, if you read it, it contends that, to me, that the time for statute of limitations began to run on January, excuse me, 10th, 2003.
If I may, Mr. Williams, can I interject? This is kind of interesting when this case is coming back again and we have one of the judge who wrote the first opinion here on the panel. And this is all fortuitous. It's all luck of the draw. Yeah. So we don't do this on purpose. But as I understand that issue, I thought it was put to rest in that first case where, and that the doctrine of equitable estoppel acts as a bar to the statute of limitations defense, and then it was properly raised in this case.
Well, I thought the first opinion reading it said that Mr. Meyer Darren Meyer had been deprived of his right to bring that issue before the trial court and the appeal court originally because of the trial court's dismissal on grounds of statute of limitations. The way I read the opinion was that on remand, he was allowed to bring up and raise those issues. Was he delayed in filing his case because of actions of my client? And that's clearly what he tried to do in this case. I think he tried to take it a step further by pleading equitable estoppel as part of his base complaint as opposed to raising it as an affirmative defense of some type, which I thought he should have done in that way.
And it's interesting because the facts in that case at least showed that Victor, and well, let's use the names of Victor and Darren because they both have the same last name.
Great.
So as I understand that, Darren testified that he presented Victor with the agreement in 2002.
That is correct.
And then there was testimony that Victor repeatedly told him that he had signed the agreement and that he put it in a safe deposit box and that he would get a copy the next time that he went to the bank. And then there was testimony that he never returned a signed copy to Darren. Then Darren said that he acted in accordance with the agreement by making payments and running the fish farm, and it wasn't until October of 2005, some 3 years later, that Victor first told Darren that he did not believe they had an agreement and that this evidence may have been sufficient to say that, hey, he detrimentally relied on his father's continued representation.
I think the whole issue on the statute of limitations was really confused at, we'll call it the 2012 trial, the last trial, when Darren Meyer specifically testified that Victor had not breached this contract until October 5th, 2005. That was when they had some kind of disturbance at the farm that resulted in a domestic violence injunction being entered against Victor. And that was his testimony.
And was it in that, or as I review it, I think it indicated that he thought he had an agreement, and for all these years he pay. Then the first time his dad says, no, we don't. So
I think the more telling part is that if I remember the testimony correctly, Darren didn't tell his father about going into his father's house on June 2002, supposedly taking a copy of what he said was a signed agreement, taking it home, getting it copied, returning the original to Victor's house. He didn't tell his father about that for 3 years. He didn't tell his father about that until he had his attorney write to his father in October 2005 saying, by the way, here's the signed agreement, and you never gave us a deed. Well, Darren admitted in trial that it was not responsibility of Victor to prepare a deed. In fact, there was very little testimony at trial about the deed. There was a lot of testimony about the agreement, but very little about the deed. And I think, if I remember correctly, Darren's testimony was, well, we may have talked about the deed at a certain time or two, but the problem was with the basic 2-page, 3-page agreement itself, Your Honor.
And how many days was that before trial? Was it like a multi-day trial in front of the jury? It was like four days? 4 days.
4 days.
Okay.
But, so I really think that the fact that Darren finally came, and I don't know why he did this, it was his testimony that Victor did not breach the agreement until October 5th, 2005. So all this other things that he alleged originally that found its way into the Meyer 1 opinion about how he was misled, it really doesn't, to me, hold water after. If you're going to say, as the plaintiff below, Darren below, saying it didn't breach it until October 5th, that just doesn't make a lot of sense. Especially when Darren testified that as the property value increased, he became more reluctant to talk to his father about this issue of this sale. He thought it would be upsetting to him, or for whatever reason, it was him that refused to discuss the underlying contract with his father and not the other way around. And that was very clear in the testimony. So I think, but if you look at the complaint, especially paragraph 17 of the Sixth Amendment complaint, it alleges that Victor breached the contract. Well, the only breach date in the contract, or the initial breach date in the contract, would be January the 1st or 10th of 2003. And if Darren took it upon himself not to discuss this with his father as the property values were going up, I fail to see how he put on any proof that he was dissuaded or misled by whatever Victor may or may not have told him. And especially with the problem of now coming to the court after one successful appeal and saying that the first breach happened on October 5th, 2005. It's pretty confusing, but if you look at their pleadings and the total testimony, statute of limitations ran in 2004, and this case should have been barred. We also argue that the arrangement for sale, as the document is called, was not a valid and viable enforceable contract. There were just too many holes in it. It was too one-sided.
This contract, Mr. Williams, it looks like it wasn't prepared. It wasn't prepared sophisticated. Maybe that's a good way to say it. You have a father and son putting something together. But let's look at that issue.
No, Your Honor. You had Darren Meyer putting something together. And he said at trial, he put most of the things they talked about in there, and he made a decision of what was important and put it in there.
Okay.
It was his sole work. He had no input from his father.
Okay. And
and he further testified that that document was not intended to be an end-all, be-all arrangement for them. He told his father, here it is, take a look at it. If you need to make some changes or want to consider it, we can talk about it later. Didn't answer the question why Darren would sign 2 copies and give them to his father if he was anticipating there would be changes to that.
And for that point, when you said about this contract not being a contract, does it include, and one of the things legally that I try to look at, does it include all the essential terms? Okay? Does it describe the property? And this one, it appears that it does.
It describes the property. It describes the
purchase price.
Purchase price, but I think the telltale problem with the document came out in the amending final judgment, I asked this court to relinquish jurisdiction because when I filed the appeal, I noticed on my initial notice of appeal that I didn't think the judgment was a final judgment. The court had basically not told these parties what to put in the mortgage, what to put in the note, or anything. So the court was kind enough to send it back, and we got an amended final judgment, but it didn't address some of the issues in the arrangement for sale. For example, the arrangement says in one, if not two places, that Victor Meyer has to sign a quitclaim deed. Yet, in the body of the arrangement, it says he must warrant that there are no liens and encumbrances on the property. That's a warranty deed. That's a big difference. Judge Barber, when he did the amended final judgment, specifically said quitclaim deed. He did not address why he eliminated the warranty provision of that. In the arrangement for contract, there's a provision that upon Victor's death, any unpaid balance would be forgiven in favor of Darren. That was not put in the amended final judgment. That's a key term. Right now, there's round numbers $170,000 still owed on this contract. The original had no monthly payment due. It said 5% interest. Judge Barber took it upon himself to come up with a monthly payment based on what he heard at trial.
And because he heard at trial, I think the son kept paying every month. Okay.
And in the original two-page document, there were provisions in favor of Darren for a 90-day waiting period in the event of defaults and how he could cure defaults. None of those provisions would be in a mortgage that was prepared pursuant to the amended final judgment. So basically, Judge Barber had to look at this after sitting through a 4-day trial and hearings. He wrote a contract for these people, and I think that's totally inappropriate where somebody's asking for specific performance. It just, to get specific performance, you need a contract that's a little more detailed than a basic contract. You need all the terms set out on what's going to happen. And when and if there's ever a mortgage prepared in this case, it can follow the amended final judgment without being the same as the agreement that Mr. Darren Meyer, prepared. I did cite one case in the brief, Friend versus Capeffs, that talks about this situation of waiting, in that case, for some stock prices to go up before people step forward to try to enforce their rights. Here we've got the same situation. The prices evidently went up on this property so much that Darren wouldn't even talk to his father about it. He didn't want anything to do with it. He just wanted to wait and hope for whatever, I don't know, but he refused to do the talking. I think when Darren gave those documents to his dad in February 2002, it was we'll say a work in progress. He told him, if you need to make some changes, if you don't understand something, we can modify these, do whatever we need to do. Let me know when you've had a chance to read them, something to that effect. And a few months later, he was in there in his dad's house, uninvited. His father was not home. And he took a copy, and that's what this whole suit's based on, is that copy he pilfered out of the home.
Well, is the contract automatically void if you pilfer a copy? I mean, that would presume delivery is an element of contract, as opposed to being signed by the party to be charged.
We take the position that since Mr. Darren Meyer decided that a written contract was necessary between he and his father, which it would be on real estate, that delivery by my client was an absolute necessity to constitute a valid enforceable contract.
So if Victor signed the contract and kept it to himself,
yes,
didn't give a copy, then the question becomes, why did he sign the copy if he didn't intend to execute it?
Well, you can have a change of heart.
Can you sign it and not deliver it and claim there's a valid contract?
Yeah, it has to be delivery. I cited the one case, Rory versus down there, they said where the one party had signed and tendered it to the attorneys on the other side. He tried to withdraw, and it was a mess, but since they had not exchanged signed contracts, it was not a contract. That was a detail, very important thing. Another important issue is, did, at the time of trial, did Darren Meyer have the ability to fulfill his obligations under this contract? We proved through testimony, and it was undisputed, and it was not even, our argument was not addressed in the answer brief, that at most, for 10 months prior to the time Victor locked the gate and kept Darren from coming back into the property, at most he was earning $900 a month gross on this fish farm. No other signs of income, no way, no visible means to pay $1,500 a month if that was in fact the purchase price. So he didn't have the ability. He did offer some testimony that he can make arrangements to get money to pay, but the case law is clear. You need to have firm commitment, unconditional commitment to come up with the money.
Did he testify that he had about $20,000 available to him?
He did. He testified he borrowed some money for student loans. Evidently, he was going back to going back to school at the time the trial was heard. Mm-hmm. And that was the only money that he was able to testify to. But by that time, it had been a year, 2 years of no payments, so $20,000 wouldn't even have caught up the past due payments.
And I thought, was there testimony presented that he said that he could be paying, he could get the fish farm up and running by paying $2,000 or $2,500, or $2,500 to $3,000?
There were two different expert witnesses. We had a witness, Mr. Tanner, testified in his opinion. He'd been running his own farm for 45 plus years, that it would cost $25,000 to $50,000 to rehab the pools. There was 106 fish pools on this farm, most of which were so overgrown they couldn't be farmed productively at that time. He said it would take at least that much money and at least a year of time to get all those pools functioning. Darren's attorney, Mr. DeLoach, called as an expert witness another gentleman that said $2,500 to $3,000. So there was a dispute as to what it would take to go from $900 a month to a fully functional farm. Mm-hmm. Another problem I had with the case, we objected to ask that Mr. Meyer's damages be limited to $99,000. We had given him some interrogatories, and we served him on August 15, 2011. On May 21st, 2012, we received answers to him, and that was the day of the pretrial conference. I asked him to detail all of his damages in the case, and he came up with $99,000, evidently the money he had paid over the time period. He didn't claim any money for not having been able to buy the property. He didn't claim any lost profits or anything else. And we think that tells it should have been limited to that kind of amount, or it should not have been granted specific performance, because he had been able to define his damages at least to the tune of $99,000.
Sir, did you want to save some time for rebuttal?
Yes, ma'am. 5 minutes.
Okay, you've got about 4 minutes.
Thank you.
Thank
Wait
you.
till later. Thank you.
Good late morning. May it please the court. My name is Mike DeLoach. I represent the Appellee, Darren Meyer. Your Honor, we're obviously here, members of the panel, we're here to ask the panel to affirm Judge Barber's amended final judgment for specific performance.
Why don't you just, the one argument that I'm interested at the moment is the delivery aspect. He's saying you bill for the contract and you take it, but there was never any voluntary delivery.
I would address that 2 ways, Judge Villani. Number one, all of the case law there's not a requirement for delivery of a contract as an element for a breach of contract action. The jury instructions that were given to the jury, two juries found that there was a contract, enforceable contract, was the standard jury instructions that say there's offer, acceptance, and performance, all of which we had in this case, and the jury correctly determined that there was. The delivery...
You're saying it's a question of fact whether there was a execution and intent to have a binding contract, and the fact that it wasn't delivered is one element that could be argued on the intent side, but that's not dispositive as a matter of law, that there's no valid contract because it wasn't delivered.
I don't know that delivery is an element unless, like in the Rourke case, where it's part of the contract that says it must be delivered in fully executed fashion, notarized by both parties. You remember in the Rourke case, it's that older case where they tried to run in a carbon copy, which just doesn't match up with our facts. Here, Victor Meyer signed the contract and accepted payments. $99,500 worth of payments on this contract. And now they're here arguing that there was no contract because there was no delivery. And quite frankly, when we were going through this process with Judge Barber, who sat down with us in the courtroom and typed up the jury instructions with Mr. Williams and I, we had this discussion, and they could not find a case that says that the jury needed to consider the issue of delivery when making a determination whether or not there's an enforceable and valid contract. Now, this is the second jury.
And in that discussion, because what was brought up, the jury ultimately came to the conclusion that your client entered into that agreement with his dad, the dad telling him, I did sign it, and that I put it away, but I have it. And so when the jury basically concluded there was an agreement, it's a question, whatever issues of fact, they resolved it. We have to accept the fact that that agreement stands, don't we?
Yes, we do, Your Honor. I mean, the jury is in the, all triers of fact, whether it be the judge or the jury, are in the best position to determine the credibility, observe the demeanor of the witnesses, consider the testimony. That's exactly what the jury did on the contract side of the case. And interestingly, Mr. Williams brings up the issue of, well, the jury awarded him $231,950, which is just the mathematical computation of the what appears in the arrangement for sale, as opposed to Mr. Darrenmeyer's testimony that it was $99,500 that he paid out of pocket. But the contractual case, the damages case, isn't under appeal. The only thing that's being appealed here is Judge Barber's amended final judgment of specific performance. I made an election of remedies after the judge made a decision on the specific performance pursuant to established precedent as to the election of remedies, and so he entered the amended final judgment for specific performance. That was appealed, and here we are today. Another thing I haven't heard before until today was that the appellant in this case is complaining that Judge Barber wrote a contract for the parties. That's nowhere to be found anywhere in the briefs. That's news to me. My suggestion is that, like I argued below, and I argued in my brief, this particular computation that was given to Judge Barber to satisfy the requirements set forth in this court based upon Mr. Williams' argument that it wasn't a final judgment, was met simply by going to the arrangement for sale itself and doing the math. I mean, it's fairly easy. And I think Judge Barber, you know, put in great efforts in authoring this particular amended final judgment. If you look at it, I mean, he weighed everything, and he struggled with the unclean hands issue and everything.
Well,
he was in the best position to observe all this.
He was troubled with the fact, and rightfully so, that here's a father and a son who had a very close relationship, and now they don't talk anymore because of this. And you could see that was very troubling for him when he talked about this unclean hands. But the unclean hands, as I see his conclusion, because of that relationship and that between the two, he ultimately ruled that though it's a close case, he did not make that finding.
Correct. He said it was a close call. And also, he cited that Faber case that says that, it doesn't have to rise to the degree of criminality or anything. You just weigh, it could be two, not so good people, but you have to weigh the equities since you're acting for an equitable remedy. And in this case, he found, after weighing that and observing all of the witnesses and looking at their demeanor, observing their demeanor, and also, listening to the testimony, weighing the credibility, listening to the experts, he found that the equities were with Darren Meyer, and he entered his final judgment accordingly. Your Honor, the next issue that Mr. Williams brought up was the breach date. There were actually two failures to perform of the arrangement for sale, the first of which involved the date that the deed, the quitclaim deed, was to be tendered, which was January of 2003. And I believe Darren Meyer's testimony in the record is that, after that happened, I kept bothering my dad about it and asking him about it, asking about it. And then before you know it, everything comes along, and we're in 2005 when everything breaks down. And then he testified that that's when I knew there was not going to be any performance. So that falls right within the parameters of equitable estoppel as very aptly described by the Supreme Court in Morsani. I mean, that's exactly what it's for. It's a defense to the statute of limitations. And this judge, Judge Barber, specifically found, and there's testimony that was taken outside the jury. While the jury was deliberating, we actually tried the specific performance case before Judge Barber while they were out. And there's pages of testimony of what Darren Meyer did or failed to do based upon this continued representation that the deed was going to be forthcoming. Mr. Williams also referred to the fact that Mr. Darren Meyer went into his house uninvited, saw the signed version, original, of the arrangement for sale, went back and copied it, and then brought the original back. If you look at all of the testimony, Darren Meyer testified at trial in front of the jury that what happened was birds come to the farm, the fish farm, and eat fish. So they have these pyrotechnics that were being kept in Victor Meyer's house because he was there most of the time. And this was his father's house. He had permission to go in the house to get the pyrotechnics to scare the birds off. It was then, at that point in time, that he saw on the table the signed original contract and went and copied it and brought it back, as he put it, to give him some comfort that we really did have an agreement. And then he marched forward from there. Now, the ability to pay. Judge Kuzum brought out that he did testify at $20,000, that he could have continued to perform. But during the cross-examination by Mr. Williams on our mini-trial concerning the specific performance count, that, hey, you're in arrears, $82,500. How are you going to have to come up with that money? Well, if you look back in the record, what happened was Darren Meyer, all the way until January of 2008, had been tendering payments at least 3 months prior to that were refused. During that same period of time, Victor Meyer filed a bankruptcy. And we all know about preferential payments. You can't pay then because then you just pay back to the trustee. You get double whammied on that. So those are the two reasons why he stopped paying. And if we go back in time now, if this judgment is affirmed, then all we need to go back to is you tender the deed, and then Darren Meyer starts making his $1,500 payments again, which he was able to make during the entire period that he paid $99,500 pursuant to this agreement. In addition, interestingly, there's a Levette case that was cited by the appellant. It's in their brief. The Levette case suggests that even if you cannot put on overwhelming evidence of your ability to pay by saying you had a check or there's a mortgage in place or a commitment letter, there is a safe harbor if you have an excuse. And in this case, there were a couple of excuses for Darren Meyer not satisfying the test of the ability to pay as set forth in other precedent. It's like Levette said, the excuse for Darren Meyer was, number one, he could not pay because they were being refused, And secondly, in 2010, October 2010, he was locked out of his place of business where he could earn the money to make the payment.
But it wasn't also testimony that he could perform. Darren testified that, yes, I could perform. I've been paying repeatedly before until the dispute, and then testified that I have this amount of money available, but I can't perform.
Correct.
And that was not rebutted in terms of his ability to make these payments.
I agree, Your Honor. And only reason
I think you're right. I think the main thing was like, here's this big chunk, but that's kind of like, it's not really the big chunk, it's whether or not he's able to pay periodically.
Thank you, Your Honor. That's exactly where I was going, and the only reason I brought up the Levette case is because it said there is a safe harbor, even in the event you can go like, hey, the best I can tell you is maybe I'll try to get it done, which some cases say is not sufficient. Finally, and I've already raised this before, and I'm not going to belabor this point unless there's some specific questions, but the issue of the unclean hands, in my brief, I cited, Canarkis and Wade and Roberts, which are cases that really describe, how you test judicial discretion to determine whether it's sufficient and it's properly applied, which is the test of reasonableness. And in this case, and I won't say it another time, but Judge Barber was the best person to observe all the bases that went into his amended final judgment concerning where the equities were to be found. And he found that they were properly with Appellee Darren Meyer. Unless the panel has any additional questions, I'll sit down. Thank you.
I like Mr. Deloach until he said I didn't put something in my brief. I'm not going to like him anymore. No, he's a fine gentleman. Page 41, on page 40 and 41, I detailed in our brief a list of the things where the amended final judgment appeared to me to be substantially different than the arrangement for sale. And on page 41, the trial court has impermissibly fashioned an agreement for the parties. That's what happened. That's what I see. So I take exception to Mr. Deloach's comments on that. Whether one jury or two juries found a contract, the way this case came out is immaterial. It was Judge Barber that had the ultimate decision. He had to listen to the trial portion that was presented to the jury, and we had a very extensive sessions outside of the jury where he listened. He is responsible for determining whether there was a valid contract, and there are some cases that would say a jury really can't determine if it's a valid contract anyway. They can say somebody signed one or not, but not whether it complies with Florida law. But in a specific performance case, Judge Barber, and he did put in his amended final judgment that his own independent determination was that there was a written contract. We respectfully disagree with that, but so the jury questions, that's the reason we didn't attack them on appeal, is that it became moot after the election of remedies were made. I think, once again, the fact that we proved through his own testimony, his own agreement to sales records, his own tax returns at trial, Darren Meyer never had personally the money to make any of these payments, especially in the 10 months before the gate was locked so he couldn't come back in. His total sales averaged right at $900 a month. No other source of income was made known to us, nothing. He didn't have ability to pay $1,500. There was a bankruptcy filing that covered some period of time. I think it was over before that. I know it was over before I got in the case, which would have covered the lockout period going back. And initially, the payments were being made by direct deposit by Darren into his father's account. At some point, he decided to start mailing checks to cover those payments instead of the direct deposit. Well, there was and still is a domestic violence injunction that prohibits any contact between Darren and Victor Meyer. Victor simply refused to acknowledge, and this was his testimony, that he did not want to be in violation of the domestic violence injunction by accepting communication from Darren Meyer, whether it was checks or whatever it might be in the envelopes that were sent to him certified mail. So there is no safe harbor provisions that would excuse Darren Meyer from not making the payments all along. Any further questions? If not, I think we'll conclude today. Thanks again.
Thank you both.
Thank you.
All right, we're going to take about a 10-minute break, and we'll be back for our final two cases.